Hello, 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 and good morning, everyone. Hope everyone is great today. Let me just get my studio up here. Hello, everybody coming in. Please smash that like button on your way in. Let's get this out in the algorithm. And it also helps the channel, and it's free. So if you want to pop out, go smash that like button. When you come back into chat, make sure you have live chat selected at the top of your chat screen so you don't miss anything. Feel that I won't be able to watch today's because today's the year that my father passed. Oh, hugs, Pierre, going down home to visit family. Well, you have safe travels, and I'm so sorry for your loss. My heart and prayer are with you, my dear, and your family at this time. Have a safe journey. May. Good morning. TK Sass. Good morning. Michelle. Good morning. Good morning, everybody. Thank you for smashing that like on your way in. So we're about to get started here, you guys. I've got it up. It should be started.
Good morning, ladies
There we
and gentlemen.
go. We need 5 more, I
Oh,
think.
come on. It's a Tuesday. The spring is getting here. It's going to be a warm day. We're beyond the snow for now. Good morning, ladies and gentlemen. My name is Greg Warner. I'm a district court judge for the 4th Judicial District. Before we begin the jury selection process, I would like to introduce some of the people who are in the courtroom and you may or may not have already met. You see my court reporter in front of me. It's her job and her responsibility to make sure that everything that is said in the courtroom is transcribed into what we refer to as a record of the proceedings. And that's important to remember because she can only take down what you say. Nods of the head and uh-huhs and uh-uhs don't get translated very well. So if you can give a verbal response, that would be great. In addition, we're going to be asking questions of everyone in the courtroom as opposed to just the people who are in the jury box. That's important because I bet when you came in, everybody back here was thinking to themselves, I am really glad I'm not sitting up there. But you need to understand that we're going to be asking questions of everyone. And because of the acoustics in the courtroom, it's the hardest to hear from especially those back 2 rows on this side. So if you can speak up, it will make her job a whole lot easier. Finally, once the attorneys start asking questions,
Ancestor
there is a tendency for everybody to speak like they normally would, which is 2 people are talking at the same time. That makes her job impossible. So please let the attorney finish their question before you give an answer, and they'll let you finish your answer before they ask another question. You've also met Mr. Sproul and Mr. Combs. They're here to assist you. You can talk to them about general matters such as parking, phone calls, those sorts of things. However, do not talk to them about this case, and they will not talk to you about it. They're not being unfriendly. It's just that they're not permitted to discuss anything about the case with you. I assume that most of you were not thrilled when you got your invitation to come join us today. However, please understand how important all of you are to our judicial system and how important the jury system is. I want to thank you for being here, and I think you should know that the United States conducts about 90% of the jury trials in the world. Many other countries do not trust their citizens to make these kinds of decisions and leaves those decisions to be made by some member of the government. When our country was formed, the people who formed our country believed that the government should not have that much authority. As a result, they placed in our federal constitution, and our state constitution has a similar provision, for a right to a jury trial. That right cannot be secured unless all of us have the obligation to serve when called. In case you're wondering, yes, I have that same obligation. Yes, I've been sitting in the same seats that you're sitting in. I do understand that it is a sacrifice for you to be here and put your lives on hold, and I deeply appreciate your participation in this process. Thomas Jefferson said, I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution. I've spoken to hundreds of jurors over the years. They all told me that they were glad that they had served. They said it gave them a better understanding of how important they were to the process, how important the jury system is to our judicial process. And they said that even though it was a sacrifice, they were glad that they had served, and given the opportunity, they said they would serve again. We are identifying you by number in court rather than by name for a number of reasons. First of all, due to the number of jurors being called, we do not want there to be any confusion regarding who we are referring to at any point in time. This is our 6th day of doing this. So there may be more than one Mr. Martinez or more than one Ms. Johnson. Because of that, it is easier for us to keep track of you by number. In addition, while the defendant, the attorneys, their staff, and court personnel will know your name, referring to you by number is to protect you from contact by the media or other persons, curiosity seekers, and the like, to protect you from unwanted publicity, and to ensure that no outside information is communicated about you through this process and the trial. Finally, after talking with a lot of jurors over the years, they all told me that they were more comfortable when they were referred to by a number in open court rather than a name. The fact that we are referring to you by number should have no impact at all on the presumption of innocence that the defendant is entitled to, or any impact in any other way as you consider and decide this case if you are selected. The case we are about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. In this case, the prosecution is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are attorneys with the District Attorney Office. The defendant or accused is Letecia Stauch, and she is being represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called an information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case? All right, thank you. Go ahead and have a seat. Before we go any further, I want to ask, do any of you have any difficulty either hearing or seeing what's going on in the courtroom? All right, looks like we have a couple. This would be juror number 33 over here. Can you hear me? Yes. Can you hear me? Okay, even with the microphone, you have difficulty hearing me? Okay. Saw other hands. I saw one over there. Juror 21. Yes, sir. Can you hear me now? Okay. So it has that, and now you can hear me? Okay. All right. Anyone else? I thought I saw a hand in the back. No? All right. Okay. In this case, 12 jurors and 6 alternates will be chosen. They will consider all of the evidence produced during the trial. The jurors will determine what the facts are based on this evidence. The attorneys anticipate this case will take 6 weeks for trial. That does not include deliberations or jury selection. We hope to start the presentation of evidence on April 3 of 2023. So that would mean finishing sometime in mid to late May. I understand the burden that such a lengthy trial places on everyone. I previously presided over a case that went 18 weeks from start to finish. So I've been through this before. I understand how impactful this is on jurors' lives. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will not be any trial on Thursdays, as I have other docket matters I have to attend to. You will be able to go home to your families each day, and no, you will not be able to discuss anything about this case with them. You'll be able to talk to them about anything else. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? And because I anticipate a lot of hands, we're going to do this in sections. So over here first. Right. Do you have your hand up, juror number 1? Okay. Where are you going? Okay. Juror 2, did you have your hand up, sir? Juror 3? Juror 4, did you? No. Juror 5? It's a Friday. Does that sound right? Oh, I see. Okay. All right. So it's not local. I got it. Okay. Juror 6? Juror 7? Juror 8? Where do you go to school? Juror 10? Yes, on the end. Okay. Okay. In the front. Juror number 12? Yes, sir. What kind of work do you do, sir? We've already had people from the Postal Service in. I want you to check with your supervisor at our break or over the lunch hour, because there are a number of employers that continue to pay even on jury service. U.S. Postal Service is one of them. So I want you to check with your employer. Does that make a difference? Say that 3 days. Okay. Tell them how long it is, and we'll check with you later today, okay? Okay. Juror 13? What kind of work do you do? All right, juror. Let's see. 16? Yes, ma'am.
Person responsible for 5 children, 8 I had to call in a friend too. But that's not an option every.
Help me understand what you mean by you're physically responsible.
She has 5 children and because I work from home.
Got it. Juror number 20 on the end. Yes, sir. 6 to the 10th. Okay. And then in the back, first row, juror 22. Okay, what kind of work is it that you do? Wait, let me ask, did you say that you work for the UCCS Police Department? You're excused with the thanks to the court. You do not need to go back to the jury assembly room. You can go about your business. Anyone else in that first row? Let's see. Juror 25. Yes, sir. All right. Anyone else in that front row? No. Second row, juror 37. Oh, wait a minute. Oh, no, that's right. Because, okay. Juror 35 is over here on the end. Where do you live? Can you? Okay. When you say all the way up north, where's that at? Okay. 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 And juror 36 over here on the end, second row. Juror 37, did you have your hand up? No? Okay. Juror 38. What kind of work do you do? And okay, I'm going to have to come back because I already went past row number 1. So, all right, juror 39. No, you be juror 39. We're going by seat number here. Okay, so you don't know when the surgeon's going to schedule it. Okay. So, but you don't have a date for when it's scheduled yet, right? Okay. Okay, juror 40, did you have your hand up? Yes, ma'am. Okay. Juror 41, did you have your hand up, sir? Okay, and juror 24, you had your hand up? Okay. Well, right now I'm asking for hardship. That's all I'm asking for. I'll ask about other things. Does the things that you forgot have to do with that? So it's a hardship? Okay, I know, and I will get to that. Okay. Last row, juror 51.
I'm self-employed and a sole provider for my house. That could take effect as well. Hard enough. Also, we have May 4th through the 16th.
Else in that back row? Juror 54. How old are the children? Anyone else in that back row? Over in this section, first row. All right, juror 29. Okay. Juror 30. Will be done long before the vacation, so the other concerns I understand, but right, yeah, we'll be done long before then. Anyone else in that front row? Juror 31. What court dates do you have? April 18th, okay. You said it's a civil case? What kind of case? All right, anyone else in that first row? Juror 32. Okay. All right. Anyone else in that first row? Juror 33.
Very bad, hear me?
All right. All right. Juror 34, did you have your hand up, sir? No. Okay. Second row. Juror 47 over here. Yes, ma'am. Okay. Juror 48. What kind of work do you do? Right. Third row, juror 56 on the end. Okay. Would you be able to reschedule that if necessary? Okay. Who else did I have? Okay. Juror 58. Congratulations. Anyone, juror 20, or I'm sorry, 59. Juror 60. What kind of work do you do, sir? And tell me about the financial hardship. Okay. Did you check with your employer about that? Okay. When was the last time that you were summoned? Oh, so not that long ago. It was like 2019 or 2020, something like that. Okay. Juror 61. And this would be April. All right. Juror 62. Okay. Then that third row back, juror 63. Where do you go to school? Back row 65. Yes, sir. kind of work do you do? You're 68? Last row? Anyone in the last row? Juror 70?
I'm currently employed and I'm afraid that this is gonna.
What kind of work do you do?
Some of these positions had three.
Anyone in that back row? Juror 71? Yes. Okay. If necessary, I can get you a letter. They can't take any adverse action against you as a result of jury service, so I can get you a letter if that would help. Juror 72, did you have your hand up? No. 73? Yes, ma'am. Of April? And is that in this building? Anything else? Okay. And juror 74? Are you employed by law enforcement? What do you do? I'm sorry, who are you employed with? Oh, I thought you were trying to get there. Okay, so you are a current law enforcement officer. You're excused with the thanks to the court. Juror 75, yes, sir. Okay, thank you. I need to go through a list of grounds that may disqualify you. Some of these grounds will sound familiar because I've already excused 2 people for them, but it's a statutory basis. Are any of you, or do any of you believe that you're related to the defendant or any of the attorneys? No response. Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or partner in business with, or surety on any bond or obligation for the defendant? That's a long lawyer question, essentially seeking information about whether or not you have a particular relationship with the defendant. Do you rent from her? Does she rent from you? Do you employ her? Does she employ you? Anyone think they're in that category? No response. Are you now, or have you ever been, a party in a civil lawsuit involving the defendant, or have complained against or been accused by her in a criminal prosecution? Anyone think they're in that category? No response. Were any of you a witness to any matter related to the crime or its prosecution? Does anyone think that they are a witness in this case? No response. Do any of you have a personal or financial interest in the outcome of this case? No response. Do any of you have feelings or a bias for or against the defendant or the prosecution? Yeah, no response. Are any of you an employee of any public law enforcement agency, or the public defender's office? Okay. Is juror 58? Yes, sir. Are you all post-certified? Is you said Parks and Wildlife, so you're employed by the state, right? Okay. I have to think about that one. So you're a public information officer for CPW. You are not post-certified, correct? Okay. And do you have any arrest powers or authority? Right. Okay. Thank you. That helps me understand it a little bit better. Anyone else? Juror 18? You still are? Okay. You are excused with the thanks of the court as well. Anyone else that I missed? No? All right. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they fit in that category? No response. Please raise your hand if you are unable to read, speak, or understand the English language. Anyone think they're in that category? No response. Please raise your hand if you are incapable due to a physical or mental limitation to render satisfactory jury service. All right, and that's juror number 35. And is that based on what you told us before? Okay. If you need to stand up, go ahead and stand up. So if you need to stand or stretch or something like that, go ahead and do that. Anyone else? Juror 10? Okay. Okay. Anyone else that I may have missed? No? All right. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're all right? And juror 35, what? Okay, listen to this question. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. Okay. Anyone in that category? No response. Please raise your hand if you served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Anyone think they're in that category? All right, no response. At this point in time, well, no, hold on. Give us just a few minutes. Juror 21, how have you been doing in being able to hear what's going on? Okay, behind you, somebody that's not using a microphone, you can't hear them? Okay. And juror 33, how have you been doing? Okay. Okay. Okay, so at this time, I'm going to excuse the following individuals. Juror 1, 2, 3, 5, 6, 7, 8, 10. Yeah, hold on just a minute until I get through everybody. Juror 13, 16, 20 at the very end. 25. Next row back. 35, 36, 38, 40, ma'am, 41. So 35, you would be excused too, and 36 over on the end would be excused. I'll come back and do it because since we're a little out of order there, it'll be easier if I come back. Five. degrees temperature. And 6 and 7. 16. 6. Six. 68. 70. All right. At this point in time, we're going to have the staff hand out a list of witnesses for you, and I need all of you to take a look at that list of witnesses. And the question that I'm going to have for you at the end is: do you think any of you know the potential witnesses? And council approach, please. All right. Prosecution does, are there any other witnesses that the prosecution intends to call which are not on that list? Defense?
Possibly Dr. Ron.
Does anyone think they know any of the potential witnesses in this case? Please raise your hand. Okay, it looks like we have a couple. All right. Juror 34 over here. Okay, how long ago did you leave the field? Okay. So you would have known them as a result of your employment? Okay. Have you had continuing contact with any of those individuals since 2013? Okay. Okay. The question that I have for you is, and I don't know what their involvement is in this case, or whether they were just somebody who was at the scene, or whether they're actually a lead detective or whatever. But the question that I have for you is, do you think that you could judge that person's testimony just as you would judge anyone else's testimony? Okay. And then juror 43, yes, sir. Okay, so you could judge those people just the same as you would anyone else? Okay. Anyone else that I may have missed? No? All right. I want to go through some instructions that may help you understand and follow through with our next discussion. And these would be instructions, if you are selected to serve as jurors on this case, these would be instructions that you would receive. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfactory of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case, and the defendant is presumed innocent. And that won't change in a few minutes when the defense gives, or when both sides give a sort of mini opening statement so that we can talk about some issues in the case. In addition, someone may ask you whether or not you think the defendant has done something wrong, or else you wouldn't be here. However, that's an improper question. We don't just randomly select someone from the street to suddenly appear in the courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against the defendant are just accusations. They are not evidence. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and unless and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may also find it useful to think of the charges in this case as similar to a recipe from a cookbook. That's because the charges have certain things in them that must be proven. Once you see it, you'll see that there's actually things that are numbered out. It's kind of like ingredients. So for instance, suppose that you wanted to have a Denver omelet and you took some eggs and you scrambled them up. You added some ham, you added some cheese, you added some mushrooms. In that case, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. In this case, if the prosecution charges a Denver omelet, that's what they have to prove. No substitutions on the menu are allowed. The prosecution has to prove beyond a reasonable doubt what it has charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you need to hear from both sides in order to be fair. Everyone wants to be fair, right? Everybody says, geez, I would want to hear from both sides. I sure would want to hear from both sides. However, that's an improper question because that is not the process that is followed in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. The defendant has no obligation to disprove the government's case. Stated differently, the defendant does not have to present any evidence or any testimony. In fact, defense counsel could take a nap at the table, could play cards, and that would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That is because it is not evidence, does not prove anything, and must not be considered for any purpose. Now, sometimes the attorneys will ask you a question designed to elicit a response from you, such as, well, I know if I were accused of something, I would make sure I took the stand and told my side of the story. As indicated earlier, however, that's kind of a trick question because that's not the process that we follow in a court proceeding. In any event, does anyone know what the number one psychological fear in the population is? It's higher than a fear of death and greater than a fear of meeting a rattlesnake on a hiking trail. It's public speaking. So naturally what we do is we bring 75 strangers and pack them into a courtroom and ask them all kinds of questions and have them respond in front of a whole lot of different people. And I want you to think about that process for a moment. Were you nervous? Were you uncomfortable? Were you hoping, oh my God, I hope the judge just moves to somebody else? And you weren't even accused of a crime, and you weren't being asked a bunch of questions by lawyers about a bunch of facts and having somebody in a jury box just staring at you. The bottom line is that it is possible that the defendant won't testify. It's possible that she will. But regardless of who testifies and who doesn't testify, and regardless of whether you want to hear something more from someone or not, the real question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone here who thinks they cannot follow that process? Please raise your hand. Is there anyone here who thinks that they would have to hear from the defendant in order to decide the issues in this case? No response. Is there anyone here who cannot give the defendant the presumption of innocence to which she's entitled under the law? Please raise your hand. All right. Juror 45. Yes, sir. That's you. Yes. Okay, and I'm going to get to that in just a second, so I'm glad you raised your hand. Before we get to the publicity, anyone else? Looks, all right, Juror 50, yes, ma'am? Okay, I think it's probably best if I just wade into it. Have any of you heard anything about this case from any source, including friends, family, the news, other media, or the internet? Please raise your hand. Okay, looks like a fair number. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media, the real question is whether or not you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone who thinks they cannot do that? All right. Juror 31, tell me what's on your mind. Anyone else? No. All right. Let me follow up with Juror 45. You said that you had seen a number of things on the media and you had formed an opinion. My question for you is, can you put that aside and decide this case based only on the evidence that's presented in the courtroom? And Juror 50, same question to you. Can you put aside what you've read or heard in the media and decide this case based only on the facts presented in the courtroom? At this point in time, I'm going to give the attorneys an opportunity to give sort of a mini opening statement. It's their opportunity to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you're selected to serve as jurors. So with that, defense? Or I'm sorry, prosecution. I did. Yes, thank you. Yes. Hold on just a minute. Yeah, we're working on it. Just hold on.
Is this better, sir? Better? All right, I'll try to speak louder. Gannon Stauch was met with peril in his bedroom, where he should have found safety and security because he was murdered at the hands of the defendant, his stepmother. Over the course of this trial, you would hear evidence that she made various choices that were intentionally made and all made while she was sane. She chose to stab Gannon Stauch multiple times. She bludgeoned him, fracturing his skull. She shot him in the jaw. You will also hear that she cleaned up the scene of the crime, his bedroom. You will hear that she purposely hid his body, hiding it up near Palmer Lake, but that she also transported his body in a suitcase to Florida, throwing him over the edge of a bridge, hoping that nobody would find him. At the close of evidence, the people asked that you would find the defendant guilty of all charges.
Okay. All right, and Juror 33, were you able to hear all of that once she had the microphone? Okay. Juror 33, I'm going to excuse you at this point in time. I just don't think there's a way that we can overcome the hearing issue for you. So we're just going to excuse you, okay? Juror 21, how are you doing? Were you able to hear everything? Okay, we're going to excuse you for the same reason, sir, okay? All right. Now that you've heard a little bit about what the facts are in the case, does that jog anybody's memory about whether or not they've heard anything about this case that's not previously raised their hand? No. Juror 12? Yes, sir.
By employment at the postal mail carrier on that specific.
Okay, so you went through that
where
on
they
what, a
had
daily basis?
incident place, I was part of my daily route.
Okay. And how long did you have that route?
I was a person that covered the route for the main person who was out for medical. I was
Okay.
during that time.
Okay. And did you go?
By the house.
Okay, that was going to be my next question. Was one of the houses that you
Yeah.
went to, was it,
My route.
that was on your route?
Clarify, that area is not a site delivery, so not house to house to house.
Right.
It was centralized boxes, so
Okay.
I didn't necessarily go to that house daily. I would go to the house if I had parcels to deliver, but a mail drop off was at a specific location.
Okay.
Area.
And I'm at least in I can only say with what I'm familiar with. In my area, there may be 8 or 10 houses that share a specific drop box. Is that kind of what we're talking about?
My memory collects, there was 2 boxes on opposite sides of the house location.
Okay.
Sure which box, that's a specific one, but that whole area, developing areas.
At the time. Okay. Okay. Anyone else? No? All right. And juror 24, you had previously raised your hand about some particular issues. Have we touched on them yet? Do you have any? What do you want to tell me? Okay. Okay. And what about the first one? Does that affect your ability to, or would that affect your ability to be a fair and impartial juror in this case? Yeah. All right. Okay. Okay. Well, I appreciate you sharing your experiences with us. And one of the things that every juror does is they bring in their life experiences. That's why when ultimately we end up with a jury, you have a number of different viewpoints. And I think that's a good thing. And those viewpoints foster what the discussion is going to be amongst the jurors. And there's nothing wrong with that. As a matter of fact, you'll even get an instruction that says that you get to use your common sense when you're deciding this case. However, you also get an instruction that says you're not to be influenced by sympathy, bias, or prejudice for or against either party. So the question becomes, based on your experiences, do you think that you can set them aside and decide the evidence or decide the issues in this case based on the evidence and the law that's given to you? No, I appreciate that. And I preside over a lot of different cases, and some of them are more emotionally charged than others. I mean, speeding tickets and those sorts of things, a lot less emotion. False information to a pawnbroker, lot less emotion. So lots of other cases don't have the emotional component, but it is important to separate it out. They get the same instructions actually that are given in this case. And so I appreciate that. Thank you. Is there anyone else who thinks they could not set aside their exposure to the media aside from juror 45 and juror 31? Please raise your hand. No, juror 37? Yes, ma'am. Okay. And I get it. I understand. Let me see if this helps. You heard Ms. Gratiano get up here and tell you what she thought the case was about. And it sounds like you've either read something, saw something in the news, heard something from friends. Is that fair? Okay. None of that is evidence. The only thing that is evidence is somebody that comes in here, raises their right hand, just like you guys did at the very beginning, swears to tell the truth, takes that witness stand, and starts telling you what they saw, what they heard, what they knew, something of that nature. You'll also see evidence in the form of photographs, diagrams, charts, those kinds of things. That's typical evidence as well. But nothing from the attorneys is evidence. They don't ever raise their hand and swear to tell the truth. They're paid advocates for a particular position. The news is reported as the news is reported. I don't know what their sources are. I don't. It's not generally. It would not generally be admissible in a court of law because it may be based on hearsay. It may be unreliable. They may have gotten something wrong, something of that nature. There are all kinds of cases that cause an emotional reaction. And I presided over a lot of different kinds of cases. And I'll tell you one that gets everybody's emotions up is abuse of an animal, right? Abuse of a dog. Don't hurt a dog. Don't hurt a cat. Everybody gets upset about that. And the question is whether or not you can decide the case based on the evidence, the facts that are given, rather than from a standpoint of emotion. Do you think that you can do that? Okay. Is there anyone else in the back? Let's see. Let's start with juror 66. Yes, sir. Okay. The charges, let me go back. The charges in this case are murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Is that what you were asking about? Okay. And what is it that you want me to explain? Okay. Okay. Let me sort of, this is a mini law lesson, I suppose. Every crime in the state of Colorado um, is composed of elements. Those are the ingredients to the recipe that I was talking about. And when you see it, there's going to be like, I don't know, 5 or 6 of them. I can't remember which. And it depends on the number of, or it depends on the crime as to how many elements that there are. The number one element is always the same in Colorado on the date and place charged, because they have to establish it's in Colorado and that it happened. So that's always the same. Then the next one is something that we refer to as a culpable mental state, language only a lawyer can love. A crime is committed by a voluntary act accompanied by a culpable mental state. A culpable mental state is intentionally, knowingly, recklessly, negligently. Okay. And there's different definitions for each one of those terms. So the prosecution has to prove every element. They have to prove that an act occurred, and they have to prove that there was a mental element. It could be intentionally, it could be knowingly. And there's specific definitions for those. In addition, the last thing that they have to prove is that she was not insane at the time. Follow me so far? Okay. Now, probably what's going to happen here is that there's going to be some experts that will testify about whether they believe she was or was not insane at the time. And they may reach certain conclusions about that. You will receive an instruction regarding expert testimony. The very last sentence of that instruction reads pretty much like it does for all other witnesses. You may believe all, part, or none of the testimony of an expert witness. So what you believe or what you don't believe is entirely up to you based on the evidence that you see. That's something that a juror does. They weigh that evidence, they look at it, they make a determination about whether it makes sense, whether it's contradicted or supported by other evidence, all of those kinds of things. And then they make the determination about whether or not the prosecution has proven beyond a reasonable doubt that the defendant was not insane at the time. Does that answer your question? Right. Cell phones off, please. Okay. It does, and here's one thing that I can tell you. I imagine that between the lawyers, the way that the process is going to work is when the prosecution calls its witnesses, the prosecution gets to ask questions. That's called direct examination. Then the defense gets to cross-examine and point out inconsistencies, weaknesses, those sorts of things. Then the prosecution then will have an opportunity to do something called redirect. That is, go over some things that were covered in cross-examination. When the defense calls witnesses, if it chooses to do so, remember, they don't have any obligation to do that. But if they choose to do that, it will be the reverse process, because the defense is calling a witness, the defense will start, then the prosecution, then the defense. At the end of both of those, in the state of Colorado, jurors have an opportunity to ask questions of witnesses if there's something that they need clarified or something that they don't understand and that maybe they need a little bit better explanation on. Now, there's a process that you have to go through in order to do that. You don't get to stand up and do your very best Perry Mason imitation, but there is a process for doing that. Does that help? Okay. Juror 71, did you have your hand up, ma'am? Okay. Okay. But it does not have anything to do with the facts of this case, right? Okay. Okay. Nope, I appreciate you bringing that to our attention. And then juror 37? Yes, ma'am. Okay, and I understand how you feel about that. All I can tell you is that what we're dealing with here is the attorneys are trying to give you some idea about what the issues are. What you've heard is not evidence. There's probably going to be people that explain what that has to do with insanity, what it doesn't have to do with insanity. It's up to you. Whether you accept it or not is an entirely different matter. Does that make sense? Is that a yes? Okay. Anyone else? No. All right. I'm going to ask the jurors to look around the courtroom. And the question that I have for all of you is, do any of the potential jurors know each other? No hands. That's good. Occasionally I get one, and that's always interesting. Let's see. So, juror 12, I just want to make sure that I have this crystal clear. You would have been on the route for this house from January 1 through roughly through at least March 31 of 2020.
Yes.
Okay. Give me just a minute, please. Council approach, please. All right, at this point in time, I'm going to excuse jurors 12 and 31. Again, you do not need to go back to the jury assembly room. But jurors 12 and 31, you're 31, you're excused with the thanks of the court. Thank you. All right. Is there anything about the nature of this case which would in and of itself influence any of you in arriving at a verdict? Please raise your hand. Yeah, sorry. Is there anything about the nature of this case which would in and of itself influence any of you at arriving at a verdict? And juror 15, yes, sir.
I am a father of 3 girls, aged 7.5, 6, and 3.5. Child abuse is one thing that hasn't run in our, but has been a concern throughout kind of the history that
Okay.
I believe I can separate that, but that is one thing that would be.
Okay. No, you did the right thing by bringing it up, and I appreciate that. Because I presided over a lot of different cases, sex assault on children, child abuse, all of those kinds of things. And I don't think there's anybody that's going to come in and say that this is a good thing, that this should have happened or anything else like that. And that part isn't going to change. The question is whether or not you can decide this case based on the facts presented in this case and the law that's given to you. Do you think that you can do that? Okay. Anyone else in this group? Anyone in this section back here? No response. How about over here? Juror 42, yes, ma'am. Okay. And I'm sorry for that you had to go through that process. I've presided over those kinds of cases too, and none of them are easy. And it sounds to me like, so that I understand the facts correctly, you were a child that was unfortunately in a very contentious divorce, it sounds like. And it sounds as though, based on whatever it was that happened in that case, your little sister ended up with the father. Okay. And that process for you has been traumatic, going through that. And just coming back into the courthouse today, is that causing you some stress? The process where it happened, was it in this courtroom or was it in a different one? Okay. And was I the judge on that? Okay. So it's just the process and coming back through this do I have that right? Okay. And do you think that you would be able to set that aside and just, okay. And yes, that was it. Juror 45? Yes, sir. Okay. And again, I'm sorry that you had to go through that, but so it sounds that you have some feelings as a result of the nature of the charges that are involved in this case. Is that fair? Because based on your own personal experience? Okay. Is there anyone else? Oh, all right. All right, give me just a minute, please. All right, at this point in time, I'm going to excuse jurors 42 and 45. And again, you're excused with the thanks of the court. Okay. Ladies and gentlemen, what we're going to be doing is taking a recess until about 1 o'clock. What that's going to do is you saw that a stack of stuff had been delivered to the attorneys. Those are the questionnaires. What will occur is over the lunch break, we will be taking a break, and the attorneys and I will be looking through the questionnaires. When we come back at 1 o'clock, the attorneys will have an opportunity to ask you some questions. I've limited the time for the attorneys to ask you questions, so if it appears that they're rushing through something, hold that against me and not against them. Here's what you can do when we take our break. You probably have someone that is wondering, a spouse, significant other, somebody that's important in your life, wondering what's happening today and whether you are on the jury and all those sorts of things. What you can tell them is that you are on a panel for the jury for Letecia Stauch. You can tell them that if you are selected as a juror, you anticipate that the trial would last 6 weeks. You can tell them that the judge said you can't say anything else about the case. You can ask for their help. You've already heard and you already know that there has been some public interest in this case through the media, through other friends, those sorts of things. You can ask for their help in avoiding any exposure to media, to opinions from other friends, those sorts of things, and say, the judge said I can't talk to anybody about it. You can't even talk amongst yourselves about it. That way they can help you avoid those opinions because it's natural for people to want to share their opinions. I know that because I'm married to a woman who has a lot of strong opinions about a lot of things, and she is happy to share those opinions with me, whether I want her to or not. So the way that you avoid all of that is you say, the judge said, I can't talk to you about it. Please don't talk to me about it. That puts the burden on me, not you, because if I were to tell my wife, look, I'm just not going to talk to you about it anymore, it would lead to an entirely different conversation. So if we can have you back in the hallway, you don't need to go back to the jury assembly room, but if we can have you back in the hallway a little bit before 1 o'clock, we should be able to start on time right at 1 o'clock. Don't discuss the case with anyone else. Don't do your own research about any aspect of this case. Most of the eating joints are north on Tejon. There are some south on Tejon. There's also a bistro in the basement, but I don't think it opens until 11 o'clock. And when you go, you need to take everything with you, your bags and all of that stuff. So we'll see you back at a little bit before 1 o'clock. And I have a question from juror 69. Yes, ma'am. No, 6 weeks starting April 3. Does that help? Okay, yep. No, what's happening is that we've been doing this for 6 days now, and we're, as you see, we started out with a big group. We're down to a lot smaller group. And by this afternoon, we'll have an even smaller group, I'm sure. That's the way that it has been. And we're bringing all of those people that are left at the end of the day, we're bringing them back, bringing them back on April 3. And that's when the jury will be selected. So, but this is the process that we're going through. Does that answer your question? Okay. All right. Thank you. All rise for the jury, please. Oh, I'm sorry. But was there one more question? Hold on. Juror 53. Yes, ma'am. Yes. Yes, during the daytime, right?
Yes.
Yes. Yeah, you would not be able to like work a midnight shift because we would have trial on the Friday. But yes, you will be able to go about and do anything that you want to do on the Thursday. Um, your commitment here would be Monday, Tuesday, Wednesday, Friday. There's also no trial on May 12th. On Thursdays, I have other docket matters that I have to attend to. So there's not a trial on or Thursday is not a trial day. Does that answer your question? Okay. Anyone else before we go? Going once, twice? No? All right. Thank you. We'll see you back at 1 o'clock. Thank you. All rise for the jury. I forgot to tell them to remember where they were sitting. Some days, you know, you get in that groove. Some days you just forget those small little things. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. We will see everybody back at 1 o'clock then. Is there anything else that we need to address at this point in time? Prosecution? Defense? Okay, we'll see everybody back at 1 o'clock then. Thank you.
Should have items.
Okay, so I will click off of the webinar. And we are going to put that up on the screen. Okay, you guys, like I said, I will be in and out of chat throughout the lunch. Yes, lunch already. Hello, K Mitch. They got rid of, I think, about maybe half, like maybe even a bit more than half. The judge went into the gallery and started dismissing people, so I didn't get to write them all down. But I've got him releasing like 40, I'm going to say 42. So we still have 33 left. We only need 5 or 6 to make that jury pool 110. Excuse me. So I do believe today it's going to be the last day of this grueling, you know, jury selection. The 110, out of that 110, there will be 18 selected. 12 jurors, 6 alternates. I initially thought it was only 16, but I did look it up, and people in the chat did tell me yesterday that they're giving 6 alternates instead of just 4. So they will pick a jury of 18 out of that 110. And they will be the ones that are going to be hearing this trial. All 18 will be in the jury box. The only time they let the jurors know which ones are going to be the alternates is when it comes time for deliberations. So they will take 6 out at that point when they go into deliberations, and the remaining 12 will go in and make the decision on this case. So that's where we're at. I do not believe, now I could be wrong, you guys. I don't know how it works. I'm in Canada, so I don't know how they do it in Colorado. But I know here, now that they've got their jury pool down to the number that they had targeted, when they select the actual jury, that is generally done in private. So I don't think that that is going to be covered. But the trial is starting on April 3rd. It's not going to be delayed because as of today, they're going to have their 110. We're only looking for 5 or 6 more at this point. And I'm sure out of the 33 that are left from the 75 that started today, they will have the 5 or 6 that we still need. So, yes, mine too. Mine too, Nana. So that's where we're at. They are on break for 2 hours. 2 hours and 15 minutes. So I will leave the live up so you guys can chit chat. Please keep it classy. Please do not mention other creators, other channels, any news outlets. Please don't mention that in the chat or you will be blocked. We don't do that here because we don't want the drama. We keep this safe for everybody. No bullying. It's okay to have your opinion, even if you think Letecia is innocent. Please just be respectable in your opinion when you are putting it to the screen. If you use any curse words, please mask them. YouTube doesn't like curse words. So with that being said, you guys, I've got a few things that I've got to take care of here, and I will be watching chat, popping in and out now and then. But generally, I will be back as soon as this starts back up again. So go make yourself a coffee, go make yourself some lunch, go relax for a bit, get up, stretch your legs, whatever you need to do. I'll see you back here 3 p.m. Eastern. Again, please keep it classy in the chat. Hello, everybody, and we are back. Okay, so we got in Mama's hand says she admitted guilt already, but by pleading not guilty by reason of insanity. I'm hoping her attorneys can't prove past psychosis. They don't have to prove anything. The defense doesn't have to prove anything. It's up to the prosecution has to prove that she was not insane. So the defense doesn't have to prove anything. They really don't even have to put on a case if they don't want to. But we'll see what happens. So I just wanted to get that out there that her attorneys don't have to, just like Nana said there, her attorneys don't have to prove a thing. They don't have to disprove a thing. They don't have to put on a case at all if they don't choose to. Let me just go back through some of these comments. Oh, hello, Marie. Marie Burks. Yes, please say a prayer today for all the victims of that shooting in Nashville. And also, I mean, with all the tornadoes and the flooding and everything, like Marie just said, it's like, I don't know what's happening to this world, but all right. Let's go take care of some business. You and Kim Mitch are awesome. Yes, you guys are all awesome. All of yous. So we should be starting up in about 5 minutes, you guys, maybe 10. As everybody knows today, we only need 5 or 6 more jurors to go through to the next round to make it to the 110 that they need. So at the end of today, if they've got 20, they've got 20. All those 20 will go through. They'll just have extras, but they need a minimum of 110. And we are almost there. We need 5 or 6 from today to go forward. So the more that they can keep, the better. Right now, I think they're down to like 30 or so. That's generally, I didn't get to hear a lot of the ones that were dismissed. Let me just count the ones that I did get. I've got 31, but I know there was more than that. So let's go 40. So we'll say that 40, because I know there was a handful more. So that would leave us with 35. So all we need out of the 35 to stay is 5 or 6. It's kind of hard when there's no microphones in the gallery, and that's where the jurors are in the gallery. So it makes it very hard for us to hear them. When the defense attorneys or the DA turns around to face the gallery, excuse me, then we can't hear them because the mics are directional. You have to be speaking towards the mic. So if you got your back to the mic speaking the other direction, the mic is going to have a hard time picking it up. Now, once the actual trial starts on April 3rd, you guys, each participant is going to have mics. There's going to be mics at the defense, mics at the DA, mics for the witnesses, mics for the judge. And people will have to remain in their seats facing the front of the courtroom. So, which means the DA and the defense, they won't be turning around looking what's behind them anymore in the gallery. They'll be looking straight ahead. We will pick up everything. The witness also has their own mic, as does the judge. So it's going to be a lot better once the trial starts, you guys. But I'm crossing my fingers here. I'm saying I think there's around 30, 35 left. And we need 6 or 5 to go through today to finally get this jury selection process done. And if that's the case, then they will not be bringing in 75 jurors, potential jurors tomorrow to go through all of this again. I have no doubt that we will have enough today to proceed. So let me make sure you guys can see. Can you guys all see the screen? Let me know if you guys can see it up, because it's not coming up on my studio. Yes? Okay. So we got the judge, who is Gregory Warner, and Jack Sproul, who is the clerk of the court. They're both back up now, and this should be starting momentarily. Keep 25 for good measure, Nana. Well, I'm thinking there's, like I said, 30 to 35 left, even if they keep half of them. You know, they'll have more than the 110, but at least they'll have that 110. And I do believe, I know here in Canada, you guys, the next part of jury selection is done in private. And what happens at the next stage is the defense and the DA are going to each have a set amount of jurors that they can personally dismiss without no cause. They can raise issues if they feel that there is with cause. That doesn't count between towards the ones that they can dismiss without cause. So if the judge feels that there is good cause, then that doesn't count towards the number that they are allowed to dismiss. And I think it's 14 that each are allowed to dismiss without cause. So that's 28 in total between the defense and the prosecution. So others could be dismissed with cause if they've done something between being selected to go to the next stage. If they've, you know, if it can be proved they've been reading up on the case, anything like that. If something's come up where they're facing a felony, they've been charged, there could be numerous amounts of things that could show cause for a juror to be dismissed. So we're going to have the jury for the 3rd, you guys, that's for sure. And I know my mic that I'm using right now, you guys, isn't the best. That's because it's the mic for my headset. I'm not using my other mic today. I totally forgot to plug it in. So does anybody, before we get going, does anybody have any questions that I can maybe try and answer? I'm not going to say I'm going to have the answer, but I will do my best to answer any questions you guys have. Yeah, the judge may tell us how he's going to proceed in the next, like, I don't know if they do it in private in the US. I know they do it here in Canada. We'll have to see what the judge says. I'm sure he will let us know. You guys know that, you know, day 2, 3, and 4, I just cut out after the last ones were dismissed because it was the same jargon every day that the judge turns around and, you know, gives the information to the jurors that were left from the day. It tells them how they should be conducting themselves, stuff like that. We will listen to that today at the end, because at the end of this, he may say how they're going to proceed with the next part of the selection of getting this from 110 down to 18. So we'll have 12 jurors and 6 alternates. No problem, Marie Burks. You take care of what you got to take care of, hon. So we're just waiting for the judge. Let's put up a banner. I don't believe I will be able to do that, Evelyn, because I've got 2 that are going to be going on simultaneously. There's no way that I can do 3. I've got 3 monitors, but you can only stream 1 at a time through StreamYard. So if there was a way that I could do it, I would, but I can only cover 1 at a time. So I will be live streaming the Letecia Stauch case. Nightly, I will be giving updates on the Lori Vallow case, and possibly giving updates at the end of each day. Once the Letecia Stauch case is done, I will go over, get the information, and post it on my community tab for the Cal City Boys and the Lori Vallow Daybell case. So I will be covering the 3 of them. And a 4th if another one starts up. And don't forget, I only cover the ones, you guys, that I've done reads on, and those 3 are ones that I've did reads on. So if there's another one that pops up that trial is going to start while these are going on, I will also cover those in the community tab on my YouTube. Thank you, Nina. So any minute now, we are going to get going again with this, you guys. Please smash the like button on your way in if you haven't done so already, and then make sure when you come back into chat that you have live chat selected at the top so you don't miss anything. A lot of people say, well, I didn't see you say that. It's because you had top chat selected at the top instead of live chat. You're very welcome, Kim. Thank you for being here. And this is going to be the last day, you guys, unless the judge says they're going to show the actual jury selection out of the 110. This is going to be the last day for jury selection. So no problem. Okay, I'm going to turn off my one monitor here and reset it because it keeps flickering on me. Hang on. You're very welcome, Evelyn. So yes, I'm going to do my best, you guys, and don't forget that's on my YouTube channel. Click the community tab at the top, and you will, and you will be able to see the updates on the Orrin and Orson West case and the Lori Vallow case. Lori Vallow starts April 3rd too. No, I don't know if they're starting jury selection on April 3rd or if they're starting her actual case. If it's just jury selection, I'm not going to be covering that. But Orrin and Orson West, I will also be putting information, what's happened in court while their trial goes on. That'll be in the community tab also once those trials start. Okay, so any minute now, you guys, they will be starting. When you do hear it, if you do hear it, please put a 1 in the chat so I know that you guys can hear it. It looks like they're running late, and I don't know how they could be running late when they had a 2.5-hour lunch break. They usually only get about an hour, or an hour and 15 minutes, but they've been 2.5 hours, and they're late coming back. Ironic. There they are. Did he hear me? Oh, you guys. I just heard the judge clearing his throat, so while the judge is talking, I will be muting. But watch chat, because I do put stuff in the chat there. And here we go, you guys. I got some halls for you, Judge. Some Benadryl, some halls. You heard the throat. Okay, so you guys can hear. All right. Thank you, Nana. Thank you, Jackie. Thank you, you guys who went out and smashed that like button. Thank you so much. I don't know what they're waiting on now, you guys, but
Thank you. May all be seated.
there we go.
Call
Here we
20
go,
CR
you guys.
1358 for People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Sorry for the confusion when you came back in. I forgot one of my most important admonitions, and that is that we follow the third grade seating chart here. So you got to remember where you're sitting when we take a break, because when you come back, you got to be in the same seats. Otherwise, it causes all kinds of consternation and confusion for everyone. So sorry for that, but you guys did an excellent job adopting on the fly, so I appreciate that. I've been looking at some of the questionnaires, and I wanted to follow up briefly with a few of the jurors. Juror 11, you said that you were unavailable on Friday, April 28th. What's going on there?
That's a one-day work event if I were to be selected.
Okay. How sure are you about the probably? I mean, I can get you a letter saying that you need to be here, but if you have to be at that work event, it's a problem for you being here. Okay. So long as I get you a letter so that the boss knows you're not on a beach in Cabo somewhere, everything's okay. Okay. Juror 24, you said that maybe is it 24? It is 24. Juror 24, do you provide care for your grandchildren? Okay, tell me a little bit about that. Okay, and what's going to happen if you can't do that? I see. So you would, so if you could switch it, you would do it on Thursdays and you'd be able to be here Monday, Tuesday, Wednesday, Friday? Okay. Okay. Juror 46 over here. You said that you were unavailable on May 9th from 9 to 11 a.m. What's going on there? Okay. Would you be able to reschedule that? Okay. And then juror 69 over here, you said that you had surgery on May 23. Is that? Okay. That was going to be my next question. Is it inpatient, outpatient? Are you going to have to stay in the hospital for any period of time? Okay. Oh, all right. Okay. And then juror 72, you had mentioned, you had put on your questionnaire that you're unavailable on April 4, something about an anniversary or something like that? Okay. You will be able to go home that night. Okay. All right. Okay. All right. So that's going to work out okay? Okay. All right. Just making sure. And juror 73, you had said that you were unavailable on April 12 at 10 a.m. What's that? Ah, right. Okay. And I apologize. I've spoken with so many people over the last few days in so many sessions. And I forgot to ask you, or I'm not sure if I asked you, is that here in this courthouse? Okay. Okay. And juror 43, you had said that this trial would prevent a financial hardship for you. Tell me a little bit about that. Okay. Okay. And juror 53, I think I got the same note from you. Tell me about the financial hardship. Okay. What is it that you do? Okay. And so for you, it's just being off of work that length of time. Okay. All right. At this point in time, I'm going to turn the questioning over to the attorneys. Again, I have limited the length of time for them to ask questions. So if they appear to be rushing through something, hold that against me and not against them. Ms. Gratiano?
Great. Good afternoon, everyone. Try to keep my voice high so that you can hear me okay as far as. Right. So thank you for coming back. First selection is without getting you to talk. So if I spend 45 minutes talking for you, you'll probably start to nod off. So I know some of you are not comfortable speaking, I get it. Totally get it. But the way that this is gonna work best is for us to hear from you. What you think, what you struggle with, those kind of things. And I want to assure you, this is a judgment-free zone. I know you're talking in a room full of strangers, but I want you to feel comfortable because I talked with you about how you. Is that fair? If you feel uncomfortable, I swear that it's not personal. I just want to know more about you. Okay? Lady Justice. Lady Justice, raise your hand. Okay. Um, about what do you think? Oh, number. More about it and scales, number 4. So here, you haven't heard any evidence. Trial hasn't started, so there's been no evidence that I presented, or the defense has presented. So in terms of the scale that Lady Justice would be holding, there be anything for the prosecution at this point? If you've heard no evidence, if you've presented no evidence. And to be clear, as far as the burden, it is 100% the burden of myself, Mr. Young, and Mr. Allen. We hold the burden for the prosecution. We have to prove all elements of the case beyond a reasonable doubt, and that's a burden that we gladly uphold. But as we stand here today, as juror number 4 has indicated, there's nothing that weighs on our scale on our side because we haven't presented anything, right?
Right.
Who agrees with that? Who thinks that prosecution, we haven't presented any evidence, but scale, there should be nothing on the prosecution side? Does anybody disagree with that? How about disagree? Does anybody disagree with that? People agree with that. Juror number 55. Hello? Hi, how are you? On your questionnaire, you did fill out some information indicating that because maybe some of the things that you heard in the media that you formed an opinion. Do you understand and would you be willing to set that aside here and allow prosecution in our case to present the evidence and uphold our burden? What do you think about that? what do you think about the media always getting information right? To being right. Sometimes. So if you're instructed by the judge that you have to set that aside, that's what you've heard may not necessarily be accurate. And also, prosecution has in the opening, that's not evidence either. You set all of that aside. That would be something that you're not willing to do. You're not willing to set that aside. Uh, 53. It's, allowing the people to present our case. Allow the prosecution. That's something that in terms of insanity. That burden also applies as well. Our burden. That's something that I agree to that burden. For number 50. Some thoughts about the plea of not guilty by reason of insanity. Have you learned or feel differently a little bit about that now, or has that changed? And so in terms of, for example, self-defense as a defense, you would have to prove that, for example, somebody was at guard and a punch was thrown. They assert self-defense. Why the punch happened, how that came about, justify or mitigate the action. I can disprove that. That would be my burden to do that. Here, the same applies. 100% the people's burden to prove. So not hearing any evidence. I'm willing to consider that. Well. So, for you, that is a very firm belief that I think most of us haven't gone through it. Be willing to follow the law, evidence, prosecution. That's something that Number 34. We talk about justice, fair and impartial. Is that something that you why do you think that that's important? Sorry, can you hear that?
I'm sorry.
You're talking about elements that you prove to Judge Reed or that you believe that you understand about what we have to prove. Does it surprise you that motive is not one of those elements? For example, the people do not have to prove. In terms of background, your life experience, how are you able to determine what's in somebody's mind, what somebody's thinking? Why is that? Right, why is that? You can't get in their head, right? Unless somebody hears like. But how do you judge what somebody's thinking? How do you come to a conclusion based on what somebody's thinking? Sure. Or think about that. Looking at somebody's actions, what does that tell you about what somebody thinks? If you look. Juror number 57. What do you think about that? Actions always speak louder than words. Why is that? So, juror number 34 pointed out, it's almost impossible to get in somebody's head. So for you, you're trying to figure out maybe what somebody. At what they say. What about in terms of credibility? What one person says versus what another person says. Juror number 15, what do you think about that? Wanting to know something about the person in order to help you in a credibility determination.
About the person to determine comes from actions, what body language.
So, and they're all under 10, right? So when you're, and I'm sure that this has come up, you've got two feuding sisters, maybe all three of them are feuding. How do you determine what are the skills that you're using? Who pulled somebody else's hair? What are you looking at? What are you considering?
You're listening to kind of what was said for it, what was happening. Happening with maybe with the toy. Necessarily trouble in going to their room for a time.
So you're not necessarily using that she said, you're looking at other things. For number 14, I saw.
And Ms. Gratiano, I'm going to interrupt you for just a moment. Juror 55, it's just come to my attention. Are you going to be okay? Because I understand that your oxygen has a limited supply for 5 hours. Are you okay? Okay. Is your battery okay? I don't want you running out. Perfect. Okay. Ms. Gratiano, go ahead.
I saw you kind of nodding along, I think. Good experience with having to determine credibility, or what do you think?
I live with 5 nieces and nephews, so fights are constant and having to determine who's at fault or what's exactly the story is.
Right. And are you you're looking for other things to make your decision as to how to resolve a conflict there?
Yeah.
What if you had to make a decision between or how would you be able to?
Probably knowing things like what exactly they've done in published or search they've done or what kind of having gone to school for it doesn't.
And in terms of listening to their conclusion, that maybe would put greater weight on their conclusion, or how you could consider their.
I think so, because it'd be more concise or there's less wavering or waffling.
Just remember, you guys, the DA that is trying to get
Number
away from their
50,
mic.
this isn't something that I've ever had to do before.
The jurors are in the gallery.
You've
There's
never
no
had to do
mics
before.
back there, so sometimes it is hard to hear unless they're
Do you feel
right up
comfortable
front.
with making a conclusion like that, having to make a decision?
I do. I mean, I have to do it on a minor scale, but having to do it for something so important, I mean,
Juror number 11, what do you think about that? Is that something that you feel comfortable doing, having to make a decision, maybe in a context that you're not familiar with?
Like most people here. And before, let alone. A lot about the legal system and it's hard work for a jury.
Right.
Like the
And in terms of your life experience, do you think that, is it fair to say that, you've been training your whole life to be a juror? About that.
Yeah, I suppose. Yeah, it's part of your service as a citizen.
And to make decisions, reach a conclusion. If, as a prosecution, are able to prove the elements beyond a reasonable doubt, feel comfortable rendering a verdict. Anybody disagree or feel uncomfortable with the idea of what we're going to ask you to do, which is come to a verdict one way or another? Anybody feel uncomfortable having to make that? Uncomfortable for them to make a judgment? That's fine, that's why we're here, but I want to know if anybody's uncomfortable. Number. Okay. Can you tell me a little bit about the kind of work that you do?
I work at
And fair to say that you've seen people at all different stages of their recovery journey. And have you been around people that are considered mentally ill? What are your thoughts on, is that on a spectrum? Is that varied? Does it vary?
like right here, you guys, when you don't hear anything,
In terms of what you've seen, is it possible for somebody to have a mental illness?
it's because the juror that she's talking to is way in the back of the courtroom. There's no microphones back there, so that's why some of the jurors we are not going to hear.
Tell me a little bit more about that. What do you think?
I just know people that have fallen through the cracks because they're mentally ill.
Okay. And when you say falling through the cracks, you mean
Not able to get help.
unable to get? Are those people that you know that still drive a car?
Yes,
So that'll work?
some of them, yeah.
Some of them. Like juror number 52 pointed out, some of them struggle with substance abuse, for example. Able to function and
Yeah, some of them are, yeah.
some of them not.
You're right.
Juror number 9. Hi. Yes, I'm kind of nodding along. What do you think about that? What do you think about the idea of somebody having a mental illness?
Everybody has, you know, different.
When you can't hear the
Drugs, for
prosecutor,
example, gambling.
Yeah.
that's because she's turned away from her mic.
In terms of evaluating definition of insanity, everyone understand your line of work in a particular way. Clinicians that you work with define insanity. Juror number 24. About the idea that there's a definition of legal insanity, and that is different in clinical context. Juror 52 works in with other people. Diagnosis and to be clear, we don't expect you to understand the legal definition of insanity. That's a very, very specific definition and something that if you make it process will fit that definition. Fit that definition, and that will be very clearly defined for you. In terms of evaluating the specific legal definition of insanity. Juror number 26. You indicated that insanity may be an individual. What about that on the questionnaire?
Growing up with, we have. Right, something we don't. Okay. Right, so in the context of being given a specific definition in this legal. happened?
Pointing out that you need to start out definition of what insanity would be. Say crazy all the time, right? You say that was crazy.
Good, bad, we don't have all context, so
Right.
I have to start and see.
You know, what do you think about that? What do you think about insanity that being used here?
But again, I think things happen in life. Just it can lead to some type of breakdown. It becomes a permit or a temporary.
And in terms of, you know, is that something that you have life experience? You've observed this.
I am a retired veteran. A lot of prior soldiers that suffered with PTSD.
In terms of, no,
Most part, yes.
number 28. What do you think about this discussion about apply something, definition of insanity that you're familiar with?
Is at times in their right. Be out there, everybody at one point in a time when you're driving a car, walking. Got people that cross, there's a crosswalk 2 feet away, but they're gonna cross right in the middle of the road. Crosswalk. Going in school zones, miles an hour, and they're still gonna go 35 miles an hour. Slow down and they honk their horns at you. Why? They're insane because they're not doing what they're supposed to be doing.
What do you think about in terms of, we talk about action scenes? What if that was somebody's intent? What if that was their purpose, was to purposely jaywalk, purposely speed? Well, that's an interesting thing because here in Colorado, like I was talking, the why is not something that the people have to. You have to prove the why. Evidence, is that something that you would use? Would certain things automatically fall into now, I can't, this is law that the judge would give you, but if you were given a very specific definition of insanity for you to follow as a juror, can you follow that definition?
Yes. Both, I should say, page by page. What is actually going on? Book and not open it. Touch the book by the cover. You have to open it up.
Juror number 64. Juror number 28 has talked about opening up the book. In terms of that, what are some of the things that I need to hear more about?
Your, evidence, evidence, you're from. What is, and do you understand, that the whole book, or at least the part that you're required to decide as a juror, also understand that while they will not sit there and play cards, I assure you that it's the people's burden. The defense attorney does not have. You're the defendant. Fine, because you're writing the book. Put a whole lesson to our burden. Yes. Life experience in dealing with credibility issues. That's something that you're familiar with doing? Different ways in your life.
Cell phones off, please.
You're talking about the way that somebody behaves. Is that something that you consider about that way of what we the way that somebody behaves? That way heavily for you when September 67 afternoon. Think about the idea of somebody, how that would affect them on a day. And have you seen juror time? That we're talking about in terms of having experience with that's something. I know that that's a personal topic. As far as acting in the world and in terms of what we talked about, if you hear two different experts talk about two different opposing sides of something, we're gonna look at to resolve our conflict.
like, juror number 11 said when I talked about, you know, to some extent. Well, maybe you didn't think that you'd be, yes, I did understand, but brought up, using your. Juror number 46. Hi. What do you think about that? Is that something that? You kind of got it to an idea, describe it as corroboration. Number 71. Hi, yep. Right back there. Is it first time you've been called in for jury duty? Right. First time for everything. And about that we don't expect it. Feel comfortable, feel uncomfortable having it come.
Five minutes.
Number 72, how do you feel about that as well? So in terms of what you do generally on a day-to-day basis. You've heard the charges. And a number of you indicated that child abuse is something that would be difficult for you to do. That would be the kind of case that would be difficult. After hearing from the judge and also myself explaining that it is prosecution's burden here to present. We still feel that being on a case that involves harm to a child is not something that they are. We do know that it will be difficult, but we expect that you would be able to hold us to our burden and let us present evidence. Word number 37. Right. I know this is probably not the kind of case you thought you'd be coming in. That's still, even hearing the charges, something that you're So again, you will receive a very specific definition of what insanity is. Well, people have different conceptions of how we define that. In terms of setting aside what you think you haven't received any evidence, right? And we all know that the media gets a lot of stuff wrong, right? Okay. So, setting that aside, would you have following the definition of insanity provided by the courts, to considering only evidence that we present in this? Is there anything that I haven't talked about? Some people might say, man, I wish that Ms. Graziano talked to me about this one thing. Want to talk, I was scared. Right, I really appreciate your time.
Thank you, Mr. Tellini.
Thank you. How's everyone doing? All right, just hanging out. Not Monday. Came back from lunch. All right. Hey, I want to thank everybody for coming. So, like when we got out and tried to arrest you guys probably would have been able to sneak out and we wouldn't have been able to do a whole lot. But I think everybody here realizes this is an important job. Well, got the important case. Family. Out. People. We're asking a lot from everybody in this room, not only in their time, but in what they will have to do. Kind of my time to talk to you about what you're going to have to do, about what the requirements are going to be, for the jury, and see which of the people might be most appropriate for it. And I'm going to apologize. Anybody ever seen the movie Groundhog Day? That's what I feel like my life is. The sixth day of it, for more stories about them omelets and late Jersey being blindfolded, then you shake stick. And so I may just try to let people do a little bit more talking for me than normally I like to talk. Sure, number 28. What is presumption of innocence? Yeah. Yes. Are you 27?
I am 27.
Okay, 27.
Not as age.
Yeah, yeah. We're done.
But the presumption of innocence is already in, not guilty until facts, evidence, educated, vindicated, or trial and judge.
Which one presumption of innocence?
First person.
Well, while you're up here, I've got now they're 12 and 14 boys. They were younger. They found the other room. Playing for younger one crying. I was on my way to that room. I was not presuming the older one is. I was wondering what the old one has done to the younger one, and it would have taken me some convincing to think that he was innocent.
Do have, history.
Remember, $49.
Can you speak up a little bit, please?
They got to hear it all the way up there. I think that's something that everybody should be entitled to. Okay, well, no, you hesitated, and I think everybody would agree, it's some innocence, it sounds nice to somebody, they accuse of stealing a candy bar, something like that. But it's harder when you're talking presumption of innocence, when you're talking about killing kids. That's 52. But personal. Our system like to really work every day. Well, if you had one of your kids was charged with something horrific, I worry about it. I worry a little bit that but it kind of, everybody wants to think, I can be fair. Everybody wants to be fair. They're asking if they're partial. Why do they got kind of two things, and as a nurse, that's something. Hopefully about that way. A lot of judgment can also change. I'm worried that the jury are going to be. That is but who knows about that? Then already their opinion. I can sketch that out of my mind. Like I just some people are over here. We're like the sketch, like you draw that thing, shake it, and it all go away. Does the human mind really work that way? You have an opinion, emotion, that opinion in, and that's the hardest. Check. I heard somebody else over here. They know who else. Oh, 19?
What everybody says innocent to proven guilty. If you've ever been in the justice system, it's not that way. It's not when it comes to the person being on the stand. You're guilty until proven innocent. If you've ever been in trouble,
Yeah.
it's hard to wipe it clean.
And it's hard to do that. I mean, it's hard, I think, you're even 19, for anybody who comes over here and asks to sit at this table accused by the state of doing something. People have no idea what's about it.
Yeah, what's really going on?
But much less when you got 3 years of them being in as a horrible,
Yeah,
terrible person. I mean, that's a sketch, like that's almost impossible.
right.
Like it's all of us potentially.
I don't think anyone in this. That they can try to shake that ass fish. Possible or. Life.
Just process. But I think common sense, wisdom.
But you're.
Just listen, don't.
Roll it to the victim.
Owing to fight and or brother-in-law is
Oh.
not involved.
Go back to 57. Also talking about like. Pretty formative. that they accept information that already was stable. So a lot of times, like they've done this like studies where, they take like a politician who, I don't know, rated and by somebody they Republican, but they're thinking everybody, they're not taking in things as but they've already formed an opinion. They take in the information. Like no scientific study, they try to worry about. Remember something about 69? Oh, number 4, you're a pilot. What's confirmation bias mean to you?
Just like you were saying, you take something that mission spice trying to give you, you already have preconceived notion that you agree with it, and you're gonna naturally agree with it.
And it happens, you don't even know what you're doing, right?
Right.
And that's why, something to be guarded, against. So so number 15, that's why you worry. Because put on your questionnaire, and don't think not guilty by reason of insanity, but consider it for murder.
Yes. Be held accountable for your actions, whether you're insane or not.
I think not guilty by reason of insanity. Journal 23. You put down, you kind of feel the same way. Insanity is no excuse for murder, especially in this case.
I personally, read the evidence, but, you applies what a 11-year or 12-year-old kid does nowadays. And they push the weight. And when they shoot them, sometimes parents are unable to terminate the battle or whatever.
I mean, you put down on your questionnaire that insanity was an excuse.
Personally, decide with deal with this.
Okay, I mean, you read, I could not be fair regarding Charles. What did you mean?
Psychological abuse. I believe I brought that for myself as I grew older. So, then I understood that it was probably I who brought that for myself. Those who were older, just I got slapped around about when I was a kid.
It's okay. Are you saying it would be good for child abuse? Because you kind of looked the other way because you were slapped around as a kid?
I would turn to a site.
I just. Depends on the circumstances, actually.
Some people, I feel
Well,
like-
it's because you don't know what's going on in their lives.
Dean, how are you?
Good, how are you?
I'm good. You know everybody here.
I do.
Yeah, in this courthouse, or I think about as long as I have. I guess, I think that everybody's friendly, but I don't know. I mean, is there anything that you can tell about any of the attorneys here or anything that would? No? What do you feel about being on this jury? 37. We have, you're 15 on here saying. So you're would be fair to say you're kind of coming in with my skins and sanity.
That's not. Not someone else that's seen them.
So all I'm saying is, what I'm getting from you is, right now, as you said, that 39, kind of shaking your head. All of it is. And as you said,
I think you're saying,
well, that's good. Well, I mean, I'm sorry. That's not what that's it. That's different. It's called policy map. Oh, yeah. That's all we're asking. Already forward thinking about those things. Same shape, start putting more.
Yeah.
Yeah.
They can be, I mean.
If you run the first, I'm pretty good. But if you pick up. I think.
really cute, it's kind of push the buttons. Gotta watch yourself. Harper, let me know.
Hold on, wait a minute. It's juror 37. We just have to identify people before they start talking. It's okay. Juror 37, go ahead.
Look. I'm asking that. I appreciate your honest. 40, 3 think about it. Yeah, like in 25. Ideally, it's supposed to be over here. But a lot of people, because of stuff they've heard, everything are over here, and we're trying to get that. Or the other 44. Got a hand. All right. Yay. Hand up. 73. How are you? I'm excellent. 37. Mental illness can be triggers or can be episodes and that time. About That's true. But law kind of requires right now, if you. Someone's good, right, that's a lot of what we're trying to do that. Law also requires in this, the rule here. Not only right now, but up until the case is done. Because you have problems with the standard. Well, I mean, you understand, like, generally, but this is a general premise that if you don't know what you're doing, or you're taking further action correctly, that we don't hold that person the same as problem. That general premise. I'm driving down the highway. Well, I think there's the dentist. Which is the movie called Crazy Mountain saying. It's only going to do something, you say, oh, that's great, but then there is legal definitions of mental illness effect and affect that person with private. But you're gonna, again, I think like what kind of said, you're gonna be careful. And you're gonna have to make- Now, some people. Well, there's some people really. Some degree. Loans is something that people. That they just don't give a lot of. Same credence to like mental illness as it would as to a physical one. Saying. Way to not good berries and sandies, it would. Getting that feeling from you a little bit, but if I'm misreading you. I believe there is mental illness. I am. Okay. Right now, you don't have any evidence. But I'm feeling. Biased by you. Okay. Let me tell you what, I talked about that for a long time. It used to be, but it's not anymore. It used to be, but it's not anymore. Yeah. Up for the legislature. 64, what do you think about what 66?
I don't know enough about this case. So if you go back on that, if none of you guys ever heard any of this, what would your opinion? And how much, you didn't have that 20 years ago, we didn't have that. So were our trials a lot fairer than what they she's off of what? I think I don't know enough about any of this case. I don't know enough about.
Oh, sorry. You're such a good answer. I'm wondering what other people think. Right? 68. I don't know anything about what 64 said. would seem a lot more fair for you to get. I don't know, but it wouldn't seem like it, I mean, isn't there something that's like it's not that so fair? Right.
I understand that. Yeah, it makes it kind of difficult.
Speak up a little bit. Please speak up a little bit. Oh, yeah.
Or, I do it. How long have you worked for CSCD? About 11 years, then you went to EPSO? Okay. How long were you at the so. Look, I'm just gonna be. You spend your whole life, much like me. I dedicated my whole life to this, is what I get paid for. And the other side. I mean, both is just this, thing, but. Oh. Yeah, that's some guy, I mean, you can't. That's neat. Working. I have fun. I know, I'm not doubting that. Yeah. I'm a very fair person. I'd love to read this case file. What do you think about being an officer? So lucky.
So I don't know, I don't know what to.
Yeah, then you're also gonna be. That's why we get to be good. Another reason why it's gonna be excellent. Okay, does that make you more or less? Shake your sketch. Aren't you 28? How do you feel about being? Why did your bosses call?
He said, well, you probably get chosen. Yeah.
Never care about being Sandy. 71?
We're
What do you feel about it?
Five minutes.
Number 9, I'll be done.
I don't watch the news. So I'm just going by what everybody else is saying. And, I want to hear everything.
Talk about. There was a new. No, well, you're right, Todd, but I mean, some people can, and some people don't understand, and I'm giving you, you're hesitating. I mean, I went to lunch today, and they put a hamburger in front of me, and they would have said, "Do you think you'd eat that hamburger?" I wouldn't have hesitated. I mean, I'd already be eating the hamburger. I wouldn't have any doubt about whether or not it's ask you the question. Why did you? How long you took? Meaning, I'm getting you. You've got some doubts about whether you get presumption.
I hear all the facts. I mean, I'm very. Everybody.
Not just listen to facts. On criminal trials, you have to start from presumptions.
Yeah.
Okay.
Yeah.
You're number 14. About being on the jury.
I think that in general, it's not about guaranteed innocence.
No, it's definitely not about guaranteed innocence.
So it's, I mean, it's we're giving you.
11.
I think like some others
Yeah.
have said, I when I saw the paper this morning with faint memory, but
Okay.
not.
Yeah.
Continues to.
We're saying I hope that's not the case I'm coming in on.
What's that?
We're saying I hope that's not the case I'm coming in on today.
No, I
No.
have no idea. But
All right, we're just about out of time. Anything else anybody wants me to know about anything? Thank you, ladies and gentlemen.
Right, thank you. Does anyone know either myself or a member of my staff? Please raise your hand. No response. Is there anything that any of you have in the back of your mind you're thinking, sorry, is there anything that any of you have in the back of your mind that you're thinking, you know, the attorneys didn't ask me this specifically, but I think it's probably something that they would want to know before selecting this jury? Anybody have any of those sorts of doubts, issues, or questions in the back of their mind? No response. You've heard Mr. Tellini ask a lot of questions about the presumption of innocence. Is there anyone here who, based on their experience, whether it is through the media, friends, what they've heard, what they think, is there anyone here who thinks they cannot give Ms. Stauch the presumption of innocence that she's entitled to under the law? Please raise your hand. All right, juror 50 and over here again, juror 43. All right, thank you. And, I'm sorry. Oh, I'm sorry. I didn't see that. Thank you. Is there anyone here who thinks that they would have to hear from the defendant in order to decide the issues in this case? No response. Um, Is there anyone here for any reason that believes that they could not be fair and impartial to both sides? No response. All right. What we're going to do is take about a 20-minute recess. During that recess, what will occur is that the attorneys and I will be discussing some matters. Then when we come back, I anticipate we will excuse other jurors and keep some other jurors. And the ones that we keep, I will have further instruction for. So again, don't discuss case among yourselves. Don't discuss case with anyone else. And if I can have everyone wait in the hallway until a little bit before 3 o'clock, all rise for the jury, please. There's box. Oh.
Gloves, I thought so too.
Oh, is that what those are?
Gloves, yeah.
Oh, do you need a box of tissues? Okay.
For you, just
All right.
in case.
Okay. All right. Thank you. May all be seated. Record should reflect the jury has left the courtroom. Ms. Stauch, are you doing okay or you need a break? Do you want to do that now? Okay. Let's take about a 10-minute recess now, and then we'll come back. And in the meantime, both sides can look this up if they want. I think it's probably more for the prosecution. Juror 73, who has the court date. It's a traffic ticket case 23T1086. She has an appearance in the first appearance center, I assume on April 12 at 10 a.m. I assume if she's a juror, we can address that, fix that. Yeah, that's what I thought. Okay. Expired license plate.
For me, it's what you paid for it.
Yeah.
Receipt point.
Yeah. We got ours late too. I don't know. Yeah, the Babylonian. Babylonian.
you get that too?
I got it with weed.
You know, I got understand these kids.
These days. What? Kids these days. I got weed and I kind of realized like nothing does.
And all these people.
I'm already
talking about prison and come out bullied.
So 23, 24, 34, 37, 39, 50. Sorry. Five.
All rise, El Paso County Combined Courts back in session. I'm Greg Warner presiding.
Thank you. May all be seated. Court will recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury is not present in the courtroom. Prosecution, do you have any challenges for cause? So these are stipulated? Okay. Did you say 37? Okay. So that the record is clear, what I have is a stipulation to 15, 19, 23, 37, 39, 43, 49, and 50. Mr. Talini, do you agree?
I agree.
And who else do you have?
Challenge 24, 34. 5.
All right, as to 24.
In your 24, I think we need to look as much at her body language and how she says some stuff as much as she exactly said. I'll note that she is a lifelong teacher, had a lot of emotion about it. And and the answer to question one. Here's my main thing. Maybe I'm the only one that. On this. Then like we people on the jury. And that she kind of felt that she had turned in 12 different people for child abuse. And that in order to protect victims and stuff like that, that we needed people on the jury that are there to protect the victims, which, for that. And I know she said that, I can. But for that one, that she owed it, I think I can't remember, something akin to, I owe it to the victim.
Well, I remember it.
Okay, so that's.
I don't see it the same way that you did, but I remember it. I get it. Okay. Ms. Gratiano?
That's for which she said.
I tend to agree. I remember the statement because when she initially said it, I knew it was going to be an issue. And you know, based on the body language that she had, I think the interpretation that I made was that she said, "We owe this to society. We owe this to the defendant. We owe this to the victim. We owe this to everybody to make sure that this is a fair process." And she repeatedly said that she thinks that it's important to put aside emotions, that it's important to engage in a fair process to everyone. And I'm going to deny the challenge to causes to juror 24. 34?
4 is. Investigator. And that's really work out. I just think there is something, I think it's a little different. Law enforcement. The other thing is. I did a lot of the, you know, cases.
He left when? 2011?
I think he said he left CSPD, I think.
Okay, all right.
You know, that's.
Ms. Gratiano? I'm going to circle back to 34. 53. 53 was. Okay.
My opinion issues.
All right. Ms. Gratiano? All right. And I don't think that her answer precludes her from considering a insanity defense. And nor does it, let me get to it. And she also indicated that she would be able to set aside any opinions that she had and render a fair and impartial verdict based only on the evidence presented. So I'm going to deny the challenge as to 53.
55. That's not feeling. That's 7. So and at gathering at Georgia,
No, that's, no, 50. Oh, yes, he is. I'm sorry. Go ahead. Yeah, go ahead. Ms. Gratiano? Well, I think that the oxygen is an issue. We might be able to resolve it, but I think it's a problem. It's problematic. But the more problematic for me is that he said he's formed his opinions and he can't change it, and he said that twice. So I'm going to grant the challenge as to juror 55. Juror 66.
You're 66 was really back and forth. He's still
Older gentleman, right? Yeah.
I mean, he seemed very, on one question, he seemed like he.
Yeah.
In your eye now. I guess, just looking at the law on this, there's doubt. I mean, all of it, I mean, but he wavers back and forth from one extreme. Like, sometimes you go like, I can't do ERI at all. Yeah, I'm totally fine with it. And it didn't seem to me just like learning about it. He just seemed, I mean, he seemed to go back and forth with your honor, seemed to go back and legitimate question about it, the safer thing to do.
Ms. Gratiano? Yeah, I think the tough issue that everybody's been struggling with, including the lawyers, is that a person can have a mental health problem or issue, but that doesn't mean that they are insane for purposes of a legal definition. And I think that's what he was struggling with. I'm going to deny the challenge for cause as to juror 66. Coming back to juror 34, I'm going to grant that one. I just think that I have every belief that juror 34 can be fair, but I also think that it puts everybody in an unusual position. This was probably somebody that you cross-examined at some point in time on behalf of a different client, and there's just something about that, and I don't know what it is, because I have every belief that juror 34 can be fair. I just don't think this is the jury for him. So I'm going to grant the challenge for causes to juror 34. And I want to make sure that I got everybody off of here. I'm going to reverse something. I'm going to reverse a ruling regarding juror 53. You had challenged juror 53, right?
Yes.
Yeah, the more important part is that in her questionnaire, and I asked her about this when we came back in, I'm going to grant juror 53 a challenge for cause based on financial hardship. She put in her questionnaire, and I followed up with it, that she would have a hard time paying her bills in light of having to serve here. And so I understand I'm denying the challenges for the cause that was alleged, but I am going to grant it based on hardship. So let's see what we have here. 15, 15, 3, 7, 43, 50, 4, 53, 55, 69. Six, 9, 10, 16, 17, right? Cutoff is 17. No. No, my question was different. We're cutting off at 17.
Yeah, 70 cards.
17 cards.
Yeah.
Is what I mean.
Yeah.
Yeah. Okay. 2, 3, 4, 6, 7, 8, 12, 16. Okay, so I have 19 total, but we're only going to seat 17. Yep. As always, council approach, please. So these two are not struck, but I'm not going to seat them.
Oh, 'cause you're just not counting.
Correct. Puts us at 120, so we're good. Okay. All right, let's go ahead and bring the other jurors in.
Two, 3, 5, 1, 2, 4. Okay, I'm missing somebody in this row. Second.
She's the only one that's left in that row.
Okay, so that's it. Okay, it's 19.
Is that the one that, who'd you have?
Um,
Or who did you not have, I guess?
I had marked a 2 down there in that row. You don't ever go.
Oh, wait a minute. Council approach. Right. All right, we're going to do this process a little bit differently. because what I'm going to do is I'm going to read the numbers of the jurors that will remain with us. So if I announce your juror number, see further instructions. If I do not announce your number, you're excused with thanks to the court. You do not need to report back to the jury assembly room about your business. In this case, I need the following jurors to stay here. Juror number 4, juror number 9, juror number 11, 14, 17. Yeah.
Thank you, Kate Bell. I appreciate that. Really helps the channel and helps me to continue to be able to do this for you guys. So thank you.
Okay, for those who are still in the courtroom, we're gonna, I have some further instructions for you, and then we have some cards. We have some cards, and we're gonna be sending Mr. Sproul and Mr. Combs around to get some information. First of all, the cards that we're giving you, keep those. Just take them and put them in your pocket and keep them. You're gonna return here on Monday, April 3 at 11 o'clock. The way that we've been doing this is we've been bringing in 75 jurors each day. This is day 6, I think. And we've been selecting jurors that we think can be fair and impartial, can put aside publicity, all of those kinds of things. And we're bringing them back on Monday, April 3. At that point in time, we will then take all of the jurors that we've selected over the last 6 days. We're going to put them all together in 2 different groups because we can't fit everybody in here in one group. So we're going to put them in 2 different groups. And we are going to whittle that group down as well. One of the questions that I'll be asking is, has anything changed between now and then? So the card that we're giving you gives you contact information for us. So if something changes, some family emergency, something of that nature, you need to let us know. Otherwise, we will see you on April 3 at 11 o'clock. It also gives us an ability to be able to contact you in the event something changes with us. I don't know what that would be, but emergencies can always happen. Don't know. So, but it does give us contact information. The contact information that you're giving us is not shared with the attorneys, is not shared with anybody else. It is only for court and court staff so that we can contact you if we need to do that. You have probably already guessed that there is some public interest or media interest in this case. There could be more between now and April 3. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions that I give to you. You can tell your friends and family that you may be on this jury. You can tell them how long you think this trial will take. You can tell them the same thing that the attorneys told me, which is they anticipate evidence in this case will take 6 weeks. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case, but you cannot otherwise discuss anything about this case with anyone, and you should not listen to any opinions regarding this case from anyone else. If someone asks you why, just tell them that's what the judge told you. You can still blog or communicate, just not about this case. You can go onto the internet. You can look at news feeds. You can do your Amazon shopping. You can do all of that stuff. You just cannot look at anything regarding this case. So if it pops up in your feed, you need to swipe right, swipe left, up or down, turn the page, whatever it is that you need to do. Just ignore that article and or that news feed and move to something else. You can still watch TV. You can still go on the internet. If the TV channel starts to say something about this case, turn the channel. You're not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television, and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia, blogs, and other websites. You're not allowed to do any research of any kind about this case or this kind of case. You simply can't do it while this case is pending. Once this case is done, you can talk to anybody you want. You can tell them anything that you want. You can tell them as much as you like or as little as you like. But while this case is pending and your service is needed on this case, you cannot talk to anyone about it. In addition, when you come back, you will not be reporting to the jury assembly room. You'll be reporting out there in the hallway. And it's likely that we're going to be in here doing some other things. So please be patient. Also, please be mindful that there are a lot of other things that are going on this floor. There are 6 courtrooms on this floor. So if you're waiting out in the hallway, please be quiet so that we're not interfering with the business of the other court divisions in this wing. I think that covers everything. Does anyone have any questions about what my expectations of them are or the instructions that I've given them? Juror number 69. Yes, ma'am. Yes, I can. If you need to be excused so that your employer knows that where you are, you let me know. I will get you a letter. Okay. Do you need one today? Okay. So what will happen is Mr. Combs is back there and he is, did you already give an email address? Okay. So what'll happen is I will get a letter and we will email it to you. If you need something else, let us know. Okay. Anybody else? Juror 52. Oh, okay. All right. I thought you had a question for me. Hold on. Juror 46. We'll be starting on Monday. We'll be starting Monday, April 3. There probably won't be evidence on Monday, April 3, because by the time I combine both juries and I got to give them further instructions, show them how to get into the courthouse and all of that stuff. So by the time we get through all of that, there probably will be opening statements, but it's very likely that there's not going to be actual evidence, people coming in and witnesses coming in. Does that answer your question? Well, you can wait until Monday because here's what we're doing. We're bringing in 120 jurors on Monday. You are one of those 120. Out of 120, we will select 18. The way the process works is that in this case, each side, the prosecution can excuse 16, the defense can excuse 16. Okay, and then we're going to have 18. So if you do the math, that's 50. And we have some extra because I've done this before, and I know that circumstances change sometimes, things happen, and those kinds of things. So I wanted to have a good cushion because otherwise we would have to start all over again from the very beginning. And nobody wants to do that. So that's why we're doing it that way. So if you want to tell them to wait until you for sure will be here April 3. If you want to tell them to wait until after April 3 to figure out your work schedule and coverage, that would probably be best. Does that answer your question? Okay. Juror 69? You will know for sure April 3 whether or not you are going to be here for the next 6 weeks. Okay? Because we will have that done on April 3 for sure. Okay. Juror 28.
Okay, you guys, we don't got to listen to all the rest of that. We have a pool of 120 that they will be picking, as you just heard the judge say. They will be picking the 18 jurors from that pool. Opening statements will probably happen on April 3rd. So this is what's going to happen. First thing in the morning when they are selecting the jury, we will only have like the audio for that part. But once opening statements start, we will have the video and audio, and that's going to be from a pool camera from one of the news sources that will be in the courtroom and pulling the camera out. So, jury selection, we still will not have the video, but as soon as they start with the opening statements and the jury is seated, we will then have the audio and video. Janelle, thank you for being here. And you're very welcome. So, any other questions? Carol, Will has been my go-to since the beginning. Aw, thank you. Thank you, thank you, thank you. So, yes, we did. We made it, you guys. 120. 120. So I thought it was 14 that they each had that they could dismiss without cause, but it's 16. So that could be 32. And then the 18. So, you know, there's going to be a lot going home because they only need, out of the 120, they only need 18. So there'll be 102 sent home. Yes, it has been a long road, Kat. A very long road. 6 days of this, you guys, my back is killing me. Killing me. So what I'm going to do this week for the rest of the week, now that we got the jury, is I'm going to get a bunch of reads done up so I can still post reads for those who don't want to follow the trial. You guys are still going to get your reads also, okay? If you guys haven't seen, I posted an update in the community tab on Scotty Morris. Go on over there and check that out. There's also a link there if you want to read the whole story, but I condensed it, took some stuff out of the news article and condensed it for you with all the important points. So, with that being said, you guys, Nana, Marie, K. Mitch, thank you so much. You guys have been troopers, been here since the beginning of this. I appreciate you guys being in here. I think I may be revamping mods, maybe adding some, maybe getting rid of some. I know things in people's life change, and they're not maybe able to be in the lives as much as they could when they were first modded. So I will be doing something with the mods. So if you do see that you are no longer modding, or if you see I added you, it's not personal. It's just what the channel is going to need going forward, especially with this trial. There's going to be a lot of opinionated people in the chat in this trial. So if you do want to be removed, let me know. No hard feelings. I don't take it personally, you guys. And I hope for the ones that I do, if I do release some, Please don't take it personal. It's just, I want to keep it to about 10 mods. So if there's some that can't do it and can't be here, then I'm going to have to replace them with ones that can. And it's nothing personal. It's just I need the chat room to be moderated in the way that everybody's grown to love here. This is a safe place for everyone. So, with that being said, if you do have an issue, mods, please email me. You all have my email address. Please email me and we can discuss it there. So it's in private. Other than that, you guys, I hope to see you guys all back here on April 3rd when we start up again. For those of you who come for the minis, I will see you for the mini reads this Sunday, 11:30 a.m. Eastern. You can get your very own mini read. So be sure to join us Sunday. What's going to be Sunday is going to be the 2nd of April. 11:30 a.m. Eastern, if you want to come and get your very own mini read. Okay, so until then, again, mods, you guys rock. Thank you so much for being here, keeping things on track. You guys are awesome. So until the next time, you guys, please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you all to the moon and back. Bye-bye for now, guys.